Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, and with me today is a very special guest, Kendra Parris of Parris Law. Hello, Kendra.
Hello.
Hi, welcome to the show. Thank you so much for coming on. Um,
Thanks for
we,
having me.
yeah, it's my pleasure. I've been wanting to do a show on this, and my audience has been asking for a show on kind of the dual topics of the Second Amendment and red flag laws. And an audience member of mine reached out and said, "You actually practice in the red flag law area," and so you were gracious enough to come on to the show, and I'm very happy to have you.
Thanks for having me. I will take any chance I get to talk about the red flag issue because I think that there's a lot of superficial knowledge and not a lot of in-depth knowledge about how these are actually being implemented and put into practice. I mean, I can speak to Florida. I know a little bit about the other states, but primarily in Florida because we've really gone gangbusters in using the law in the last year and a half. So
Well,
yeah.
I know that what you're saying is true because I know congressmen in Minnesota. So that whole superficial knowledge thing, I 100% have seen that in the wild, and it's very interesting when when you just talk to lawmakers casually and kind of get their opinion on these very deep legal issues, and you realize that the decision makers are basing their decisions on some tenuous facts, we'll say.
Yeah.
Um, so why let's start out this way if we can. Can you just kind of summarize, I guess, your practice or your experience for the audience so they can get to know you a little bit and know why you are qualified to talk on this subject. I've spoken at a very high level about the subject and my personal opinions on it, but it is very much the superficial knowledge you're talking about. We don't have a red flag law in Minnesota. I'm opposed to one, but I'm curious about how they actually function.
Sure. So I guess you could broadly say that I'm a civil rights attorney in Florida. I do a lot of mental health work, mental health defense. So that would be what we call the Baker Act here in Florida, which are your 72-hour involuntary mental health examinations, involuntary treatment. You've got what's called the Marchman Act here, which is involuntary substance abuse treatment. So I do defense on those, and then some domestic violence injunction. I've never done criminal law before, and civil work. And so, because I was doing mental health work, when the law here in Florida was passed, the RPO law or red flag law, like we call them RPOs here, risk protection orders.
Right.
Uh, a lot of them are stemming from involuntary examinations, mental health examinations. So people would get what we call Baker Acted in Florida, and then they would get out of the Baker Act facility, 2, 3 days later, and some sheriff would show up on their door. A sheriff's deputy would be like, "Here's your RPO paperwork." So even though they were, sorry, I've got my dog here.
Oh, not a
So even
problem.
though they were the released from the facility by the doctor saying, this person is not an imminent danger to himself or to others. They were still hit with the RPO petitions. And I was finding I was getting phone calls from my existing Baker Act clients saying, "Hey, now I've got this weird petition that's before me. Can you help me?" And I started getting involved with it. And because I'm a huge Second Amendment supporter, it seemed like a really good fit. And, I won the first one here in my home county of Orange and started getting calls from across the state. And one thing happened and turned into the next. And so I've been kind of out on the front of dealing with these sorts of cases. And it's a big part of my practice now.
Yeah, I love how law kind of works out that way. It's like, well, you did something, someone heard about it, and poof, you're a specialist. So-
Yeah. I mean, I don't want the law to stick around, but it's really been an interesting year and a half because there are just so many constitutional issues that are involved with these. It's not just Second Amendment. Obviously, there are First Amendment implications, Fourth Amendment, Fifth Amendment due process. Obviously, there are a lot of 14th Amendment issues as well. And so, it's been intellectually stimulating, frankly, from a practice standpoint.
Yeah, and one thing that really stuck out to me with what you were just saying is you mentioned that the sheriff is showing up with these, and I think a lot of people's perception or understanding of how red flag laws work, and this is certainly my perception, is that it's your neighbor that's calling about you because maybe you were outside, drunk one night and ranting at someone on the phone, like you got one of those late night telemarket calls or whatever, and so then they think you're mentally unhinged, so they call the police. But you're saying that these orders are originating basically from almost like a docket report from people who get the Baker Act hold, is what you're seeing.
Sort of. Like everything depends on the jurisdiction. So we've got 67 counties here in Florida, and every one of them is doing something a little bit different. But the way that they are coming up is, yes, there'll be about 50% of them, I would say, start when there's a Baker Act call. So somebody's like a family member's concerned that they might be suicidal, or they've made some sort of mention. And the Baker Act gets way overused. And
Right.
I mean, this is why I've been doing defense on it, is because it's so overused. So it's only supposed to be used for people who are suicidal with a plan, meaning that they've got, the gun ready and they've expressed that they were intending to use the gun. It can't be something like, yeah, well, I've thought about suicide before. That's not supposed to cut it. But so people will get taken in under the Baker Act properly or improperly, for suicidal ideation or expression. And then they'll be quickly hit with an RPO. But I've also seen it in the context of school kids. Will say something stupid during school, or a lot of I do find that it's a lot of middle-aged white guys are getting into fights with their spouse, and then the spouse will call it in, and the police have to be the ones to actually file the petition, but the affidavit that they're using will be of the spouse. So even though family members in Florida aren't allowed to themselves petition, they're backdooring it in through just basically filing a police report. So it's all different variations of circumstances that are leading people to actually get hit with these, but 50%, I would say, are springing from the Baker Act.
Okay, so family members aren't allowed to petition for the RPO or for the Baker Act?
No, not for the RPO. They can't actually petition for a Baker Act. It doesn't happen very often. It's usually law enforcement that does
Okay,
a Baker Act,
gotcha,
but yeah,
gotcha.
so law enforcement is the only entity that can actually petition for an RPO in Florida.
I see. So that is a little different than the proposed law in Minnesota would allow anybody to make that call, and they would basically have to show similar, I guess, probable cause for a regular protective order.
Yeah.
Except I guess the difference would be it wouldn't necessarily have to be a threat against themselves. They would just have to present enough evidence for probable cause. This is, of course, on the formal hearing. The ex parte hearing gets a little bit weaker, but they would have to present enough to the court that this person was a risk to someone else rather than just themselves. Which, with a traditional protective order, you'd have to show probable cause that you were at. Or by, I guess it'd be preponderance of the evidence that you were at risk from the person to get the protective order. So that's an interesting distinction.
Yeah, and there's already been legislation introduced from one of our Democratic lawmakers that would allow family members to be the ones to petition. And I obviously, I don't like these at all. I don't like risk protection orders. I don't think they serve a function that didn't already exist in law. But adding family members fills a hole that doesn't exist. Because if there is a family member who's concerned about somebody who has a firearm, all they have to do is contact law enforcement, and law enforcement will initiate the RPO. When you allow family members to just directly do it, you're inviting the same sort of abuse that I see in the domestic violence injunction context, which is a whole lot of frivolous petitions that can be granted based on a he said, she said, no additional argument. The court, you've got, it's usually the woman in the relationship basically alleging based only on her testimony that the man was violent with her. There's no pictures, there's no police report, there's no nothing else. And the judge looks and says, well, I weigh her testimony to be more credible. Boom, you've got a domestic violence injunction. And I worry that you're going to have a same sort of issue. You can claim that the burden is clear and convincing evidence, but when you've got a standard like you've got in Florida, which is basically just, is somebody a significant danger based on any relevant evidence? It doesn't matter whether your burden is clear and convincing evidence, because the standard doesn't mean anything. So, allowing family members to actually go in and directly petition, I think, am I allowed to swear here? It would be a shit show.
You absolutely are.
Yeah, it would be a shit show. Yeah.
Well, let me tell you a little bit about me. I'm about as pro free speech as it gets. The only thing I tend to ask my guests is that they refrain from using derogatory slurs because YouTube hates it. And but other than that, if however people want to express themselves is up to them. So I don't police that. But yes, you're welcome to swear or have controversial opinions about things like how dare you suggest that crazy people need to have their guns. Like that one would be.
Yeah, well, that, like, all of the headlines I remember, because there was the regulation that was passed with respect to individuals who needed, their Social Security benefits to go to basically somebody who could operate on their behalf, at least with respect to the finances, a conservator or whoever you want to call them.
Right.
And shortly after the election, obviously, that regulation was pulled back on by Congress with the Congressional Review Act. And, the headlines were just breathless. The Republicans want to make it easier for mentally ill people to have firearms. Well, the regulation was blatantly unconstitutional. If it had gone into effect, you're talking about people who maybe have trouble with managing their own money. That does not mean that they're incompetent for the purposes of owning a firearm. And there was no due process to have this administrative agency actually be the one, Social Security Administration, to determine whether or not somebody is allowed to have an enumerated constitutional right. You'd have to be deliberately obtuse not to see the constitutional problems with it, but that didn't stop the media from just going hog wild with this notion that, the Republicans want crazy people to have firearms, which I found to be preposterous. It was stupid.
Right, especially when a big chunk of the role of the Social Security Administration, or I guess their motive, is to actually add and service people. That propagates their budget, which propagates their existence and secures their jobs. If they didn't have people coming in, there wouldn't be a Social Security Administration. So then to take that and use that sort of conflicting purpose to eliminate a right is particularly egregious, in my opinion. I have a minor request. Do you happen to have a pair of headphones?
I have buds that I can try.
Can we try that? Because for some reason, at some point, my voice is coming through your speakers and being picked back up by your microphone. I hate to ask that.
Not a problem.
Okay. Sorry.
Give me one.
All right, guys. So while Kendra... Here, let me... Okay, while Kendra is away for a moment, let's talk briefly about what specific laws we're talking about, just in case people are a little bit behind in the stream or whatever. We're talking about the idea of a red flag law. A red flag law is where law enforcement gets some sort of notification that a person might be mentally unfit and therefore a danger to own a firearm. A lot of people are on the surface in favor of a red flag law because we don't want crazy people owning firearms. So what they do, or the idea is that either in some states, an individual can contact law enforcement or even file a petition on their own, and they can therefore move to have this person have their firearms removed for safety purposes. The fear of many Second Amendment advocates is that this would be an abuse of their constitutional rights, and that would cause gun confiscation when it shouldn't otherwise occur, and could be even used for harassment purposes. Okay, Kendra, you're back. Can you hear me okay through your headphones?
I can hear you. Can you hear me okay?
Yep, you are great. Thank you so much for
Okay.
doing that. I didn't catch it when we were
No
kind of
worries.
doing the sound check in the pre-show, so
No,
but
it's not a problem.
yeah, so I was just explaining how red flag laws sort of work at a very high level for some of the people in the audience who may not be familiar. The other law you're talking about primarily is the Baker Act in Florida, which is uh, you categorize it as basically a 72-hour mental health hold. That's where well, maybe actually you should probably explain the Baker Act since you're the experts. Can you explain kind of
Sure.
specifically what the law is for, and then if you know any kind of history about it,
Yeah.
or when it was enacted, or how it's been implemented or interpreted, that would be wonderful as well. Uh,
Sure.
yeah,
So the Baker Act came along in 1971, and every state has something like it, but it was actually meant to protect the rights of the mentally ill because up until that point, it was very easy for somebody to make a casual allegation or to maybe want to get rid of his wife and just have them committed for an indeterminate amount of time into a mental hospital. And so the Baker Act came along to give some due process protections to people who are accused of being mentally ill. And the way that it basically works, and this is not only in Florida, but this is based on federal jurisprudence, is that somebody has to not only have a mental illness, but because of that mental illness, based on recent behavior, they have to demonstrate that they're a harm to themselves or to others. There's a third category, basically somebody with a mental illness who is incapable of taking care of him or herself. And this might be in the form of somebody who's just, not actively suicidal and not threatening harm against other people, but is so schizophrenic that they don't know how to bathe or eat and that sort of thing. And so a person can be taken in either by the word of a petitioner, that can be a family member at this point in Florida, who can go to the court and file an ex parte petition. That rarely happens, though. It can be a law enforcement officer who just encounters the person and takes them into the psychiatric facility for the 72-hour examination, or it can be a healthcare provider. But once they get in there, this is for examination purposes only. This is not for treatment necessarily, although they can get that while they're there. But it's for the psychiatrist to figure out whether the person actually needs longer treatment. And so within that 72 hours, they can either have the person admit voluntarily for a longer stay, or they can discharge the person, or they can file a petition with the circuit court. And this is where mental health adjudication happens. So if they file a petition, it's on behalf of the state, even though it's the facility that files it, then the person can be committed pursuant to an actual hearing before a magistrate. And so, if that happens, if somebody is actually taken in under the Baker Act and then they're put through a hearing and they're committed for additional treatment periods, like, say they're in for 72 hours and then there's another 5 business days that goes by, they sit for a hearing, and then they're committed for another 2 weeks,
sure.
just for example. That's an adjudication, and that means the person is permanently banned from possessing or purchasing a firearm at that point.
Okay, so for overlap of the Baker Act and the risk protection order, is there my personal curiosity, is there any sort of bar on using the fact that a Baker Act hold was placed on the person as evidence of a need for an RPO? I mean, we know that basically people are getting the RPOs as a result of these Baker Act holds, but are they supposed to be restricted in using that hold against them? Because it seems like in the interest of due process, a Baker Act hold would not be able to be used as evidence against the person. It would be the results of the psychiatrist read on it, but it sounds like it's functioning in the opposite way.
Yeah, no, it's interesting you put it that way, because I have a case right now. You've got rules of evidence at play here, right? Because you've
Right.
got psychotherapist patient privilege. And so you've got law enforcement, who are the petitioner in the RPO case. Law enforcement is also the one that initiated the Baker Act. Well, I've got a case out of Volusia County right now where the sheriff is actually subpoenaing the Baker Act records, despite psychotherapist patient privilege. And I mean, what a swell world it would be for cops if all they had to do was initiate an involuntary examination, at the same time initiate an RPO, and then there's no longer any privilege. It's really, it kind of blows my mind. And I also can't get attorney's fees because this is a sort of situation. They also tried to pierce spousal privilege. I would be asking for sanctions, but I can't do that in an RPO case because there are no attorney's fees. But it's really, yeah. So yeah, they are using the Baker Act against people. Now, I think that the person should be able to use the Baker Act in support of their own defense. If the psychiatrist released you within 24 hours and said there was no reason for this Baker Act in the first place, that should be helpful to your defense, I would think. So far, that hasn't seemed to be the case in any of my cases. That doesn't serve to assist my client. So I just let it go. Yeah.
So can we briefly touch on, I guess, I don't know if you have cynical thoughts like I do about just the nature of ex parte proceedings between law enforcement or prosecutors and judges. In Minnesota, one example I can give is we have I guess there's a nationally recognized 36-hour period that you can hold someone without probable cause. But we have that 36-hour hold period in criminal defense, where basically you have to either be charged or released in 36 hours, which means they have to come up with sufficient probable cause to charge you. But there's some exceptions to that, like a weekend doesn't count, holidays don't count. So that 36 hours can very quickly turn into 72 if you're arrested on like the Wednesday at 12:01 a.m. before Thanksgiving. You're going to be in jail until Monday. But we also have another portion of that, which is a 48-hour probable cause determination, where they can, without a hearing for the person, they can just do a probable cause determination to continue holding them. And that one doesn't have as many restrictions. So it's a much more strict 48 hours. However, what we end up having is that judges get on the phone with a prosecutor around 6 a.m. on a Sunday for everybody who is arrested on Friday. And then they just greenlight everything. Yes. Okay. Yeah. And it's a probable cause statement. It sounds like that's kind of how the Baker Act and the RPOs are working, where law enforcement is making these petitions and then law enforcement is doing an ex parte petition to the court. Am I reading that correctly? Is there abuse going on with that?
Well, all I can say is that I know that 99% of the ex parte petitions are granted. And I know that the vast majority of them don't take place even in person between law enforcement and the judge. It's a phone call.
Right.
And that's the hearing. And so, to claim that they're anything beyond rubber stamps, I think is pushing it, just based on the numbers, which are kept by, we have the Office of State Court Administrator, which is an arm of our state Supreme Court, which keeps all the numbers. The counties individually have been turning them in for the past 18 months or so. And, I guess it's pushing 3,000 petitions at this point. 99% of the ex partes are granted, and about 95% of the final hearings, are final petition hearings, I guess you could say, the order is granted. So,
okay. So there's the ex parte problem, which means that basically all of them are getting approved. Are you familiar with any of them that weren't approved? Like, did you encounter any of those?
Not personally. No.
Okay. So you just know that one exists somewhere.
Yeah, based on the numbers, apparently, because I wouldn't even hear about it. If the ex parte weren't granted, they're not going to push for the final. And I'm never going to get that phone call as the attorney, because, it's not going to go anywhere. So. Right.
So, but you're saying 95% of final orders or final determinations are being approved, which means what kind of numbers are we talking about of these RPOs are being filed?
Like how many in sheer numbers?
Right.
I think, I can pull it up. I think that the latest that I heard was about 3,000 since March of 2018.
Okay. That's quite a few. And that's
Yeah, it's a lot.
Florida wide or statewide, or just
Right.
limited to a particular county?
That's Florida,
Okay.
Florida wide.
So that's roughly what Florida's about 33 million people, I think, if I remember the election night
We're
map.
s- we're 17 or 18 million, I think.
Oh, really? I thought it was more than that. Okay, so then you're talking about what, 0.2%? I think, I don't know if my math is right, but that's a significant number. 3,000 is very high. To give people an idea, there are roughly 8 to 10,000 murders that occur in the United States each year. So having 3,000 risk protection orders, they're not treated as criminal proceedings, right? They're treated as
No.
civil.
They're deemed civil. I would argue that they have some quasi criminal, aspects to them, but they are technically civil.
Right, but the evidentiary standard is civil. You said it's clear and convincing.
Right.
Eh,
Clear and convincing evidence. Right.
right. So which is fascinating to me because we are talking about removing a fundamental right, and it's a process that entirely involves the criminal justice system. Yet we've just gone ahead and gotten rid of that pesky beyond a reasonable doubt standard. Uh,
Yeah.
okay, so I guess let's kind of move into, if we can. Well, actually, let's take a minute. I do have a couple comments and questions from the chat that I want to get to, and then let's move into kind of the start to finish function, from sheriff knocks on client's door to how you walk through the case, in just a minute. So if you can kind of get ready for that while I read these questions. And some of these questions I think are directed directly to you. So,
Okay.
but if there's anything you can't answer, you're not obligated to. So LaPierre Hammer for Prison says, LaPierre said in a 2017 Face the Nation interview, the NRA, quote, supported the existing law on automatic firearms, and in 1986 said repealing it was a high priority as the NRA supports the right of law-abiding individuals to own any firearm. Hashtag repeal the NFA. Do you have any thoughts on the National Firearms Act, the prohibition on short-barreled shotguns, fully automatic weapons, or the NRA? I guess to make that question a little more broad.
Well, I mean, I don't know that that's really my purview. I mean, my personal view is probably more radical than most people's, because I think that the civilian population should be able to have any sort of weaponry that the military has. That's a pipe dream, though. I mean, it's so.
No, but
I'm not gonna.
it may be a pipe dream, but we are friends automatically. I want my own McNukes.
Yeah. But I really can't. Are they? I mean, I think there's a distinction between are they legal and constitutional versus are they wise. As far as constitutionality goes, right now, I mean, it's constitutional. It is. The Supreme Court says what is constitutional and what is not, and so far the Supreme Court has said that those particular restrictions are constitutional. So
now, I'm going to push back on this because I want to. They have said that, but there's a lot of suggestion that US v. Miller was a really shorthand decision, and it is alarmingly short. It's only a couple page opinion, and that opinion paved the way for the National Firearms Act to persist and grow and to restrict things, even as far as suppressors. Now it's being used to ban, or not ban, but effectively ban bump stocks to make them Title III items. So do you think that the court is due for a review of something like US v. Miller, or I mean, I find that the court has been really hesitant to take Second Amendment cases in the past couple years. So I didn't know if you had any thoughts
that's
on
the
that.
problem. Like, I don't think that that's a case they're going to take up. I don't think now, if there were another assault weapons ban, I could see the court as it's currently comprised actually taking up another assault weapons ban eventually. Maybe not. I mean, they took the low hanging fruit in the New York state case. Basically, those restrictions were patently unconstitutional. And New York even caved, I guess, what was it, last month, and said, okay, we're not going to, we're taking it back now. We're not going to, so this case is moot.
We'll allow you to drive a gun outside of the city.
Yeah.
What a weird restriction that was.
Yeah. And so, and then the Supreme Court said, no, we're not mooting the case. And that makes me think that they've got something they want to say. I don't know whether it's, delineating what level of scrutiny is involved or what, but they've taken the most painfully obvious cases. The rest of it's being made at the Circuit Court of Appeals level. So,
Right. How is
I
it?
just don't see it happening.
On a personal opinion, how is it anything short of strict scrutiny? We have an enumerated right. It's clear and unambiguous that it shall not be infringed. Any other right that is as clear as the Second Amendment, we would unequivocally say is strict scrutiny. I mean, it would be similar to saying that the Third Amendment is subject to possibly intermediate scrutiny, which is just nonsense, right? The government shall not quarter soldiers isn't subject to some idea. Well, maybe they shall. So I didn't know if you had any opinions on that other than that were different from mine, but.
Well, I do. I find it really troubling how the federal courts are really all over the place, because if you look at post-Heller jurisprudence, there's something of a two-step process that the courts go through, broadly speaking, to determine whether you even get to a heightened scrutiny. And so the first step is, does the regulation or the law burden actual Second Amendment, activities? Does it even fall within the scope of the Second Amendment in the first place? And what a lot of courts have been doing in order to make that, and if it does, then you move on to some form of heightened scrutiny. But you'd have to answer that first question, and they've been answering that question by going into that Heller dicta, the famous Heller dicta, that nothing in this opinion shall be, held to second guess the longstanding prohibitions on possession of firearms by felons and the mentally ill. And so they'll look at the regulation. Say if one of the less friendly courts was looking at an RPO regulation, they would say, well, we're not necessarily dealing with felons, but people who have maybe done something kind of bad, like something threat-like, and we're dealing with people who are allegedly mentally ill, even though it's not a mental health adjudication. And so, that's within the Heller dicta. We're saying that this doesn't even burden Second Amendment activity. And so we're not going to get to heightened scrutiny at all. Now, that's not the route that most of them have taken. But some of the courts will say, obviously with something like a red flag law, that obviously burdens Second Amendment activity. You're basically taking away somebody's firearm rights for a year. And that's, not just to have them out in public and not just to, be able to purchase certain kinds of firearms, but to have any whatsoever and ammunition. I keep losing my train of thought here.
No, I think you're. I think the reason you're losing your train of thought is because
I'm dabbling.
No, that's okay. No, it's going. It's great. You're spot on with in the same way that I see the court as summarizing what you said. Scalia, I think Scalia bumbled Heller. I think he had a much better opportunity to clarify Heller. I'm really annoyed that he tried to make some common use distinction that would suggest that a fully automatic weapon wouldn't be common use for the national defense. Like, that was a really weird thing. And that similarly, that a semi-automatic rifle wouldn't be a common use item, but handguns are. It's like, wait a minute. The most common use item for defense of the nation would be like an M4. I mean, it'd be a fully automatic version of an AR-15. That's what our soldiers use. So by him kind of putting that out there, he was really trying to protect the handgun itself as an item of personal defense. But he also left the door open where these modern sporting rifles and even fully automatic rifles are further alienated from that analysis. And because it comes from Scalia, it's then a hammer of liberal justices to say, well, look, even Scalia said this. type thing. So
yeah, and like going back to what I was saying before is basically like, because your original question is how is it not strict scrutiny?
right.
And I think it's a good one. So like for the courts that actually do get to step 2 and are applying some sort of heightened scrutiny, then you've got another bifurcation. And that is, does the regulation impair the core of the Second Amendment right, which pursuant to what most people take Heller to mean is the right to keep and bear arms for personal protection in one's home, which is going back to what I think you were talking about with respect to an attempt to basically protect the handgun.
Right.
Which has led to unforeseen consequences. And the Supreme Court hasn't gotten its act together for the purposes of coming in and saying, look, if you're going to bring a Second Amendment challenge, intermediate scrutiny applies here. Stop using dicta from Heller because you could make anything out of that statement that you want to. And the federal courts have been doing that. But yeah, no, there are problematic aspects that came out of Heller. Combined with a very clear statement that it's an individual right. And at the very least, we can't be applying rational basis review. So,
yeah. Thank God he at least got that in there. Yeah. Okay. Nimrod says, hi, Kendra. Your thoughts on the recently passed California red flag laws passed today by Gavin Newsom, particularly their potential for abuse, and will this spread to other states? Are you familiar with California's red flag law?
No, I know that they've got some sort of seizure. I saw the headline. I didn't read the article, so I don't want to speak on it.
Sure.
I have a feeling it's going to see a constitutional challenge, though.
Yeah, that's a question I want to get to in Florida is, are there constitutional challenges coming, or have they been attempted on the red flag laws so far? And it seems really young still to actually get a red flag constitutional challenge up to the Florida Supreme Court. But
it is. So I've got one in the appellate courts. Actually, I've got more than one, but I only have one that's at oral argument. So oral argument will be on the 22nd. Another appellate court in Florida has already ruled the law constitutional. It was a tragically bad. With all due respect to the appellate court, it was just a terrible decision. So they basically said that strict scrutiny applies, and then they didn't apply strict scrutiny at all.
Thanks, guys.
So I've got one going, and if I were to get it to the Florida Supreme Court, it wouldn't be before halfway through next year. So yeah.
Okay. I was kind of curious on how that process is going, because that's the nefarious part of these types of laws. You've got a law that may be unconstitutional. You'll have 3,000 plus people. By the time it gets to the Supreme Court, probably 5,000 to 6,000 people who will, if it continues at the current pace, 5,000 to 6,000 people who will have their rights infringed before the law can even be weighed for its constitutionality. And it seems like there are real issues with the constitutionality of it, especially with, I guess there's the as written the facial aspect of the law versus the as applied aspect of the law. And it seems like you guys definitely would have an as applied challenge for a violation of due process. And that's simply going to be statistically based in a similar way to how the FISA warrants have been attacked, where we've got this rubber stamp process of 99.9% of these petitions going through. But
that's an interesting analogy. I'm actually going to have to look into that. That might be a good legal strategy to use in some of my future appeals. I don't know.
Oh, well, yeah, go for it. Don't cite me, though. They don't like it. No, I'm just kidding.
Analogize to FISA. I'm sure they'd love it.
Right. Ryan Case says, today is my 23rd birthday. When this VIX situation started, I fell into deep depression from seeing how evil my heroes actually were. Thanks for helping me get back on my feet and have a sip of whiskey for me. Absolutely, buddy. Nero says, Leighton Gay and Kevin Nash was assaulted in 92. What? Are you familiar with Kevin Nash?
I've heard the name before.
He's a pro wrestler like WWE or whatever. Or he was?
I used to watch that all the time when I was growing up in Okinawa. We could only get 3 channels, and then WWE came on like 6 hours out of every day.
Wait a minute. So
But I don't remember Kevin Nash.
you grew up in Okinawa?
Well, with 3 years, my dad was stationed there. So
Okay.
yeah,
Are
there's
you
nothing but WWE all day long.
are you an anime fan at all?
No, not particularly.
Oh, okay. Good. No, I'm just kidding. That's completely a joke. Completely a joke. Mop Sync says, looking forward to tonight's show. I plan on watching while drinking a brandy old fashioned. Cheers, sir, from this humble Mop Sync. P.S. For a commie liquor, Russian standard is a vodka produced in Russia and sold internationally. Some of these are inside channel jokes, but I've got a guy on tomorrow, and we're discussing the recent issues with Blizzard, the video game company, and the NBA, and this weird capitulation to China that's been going on. So I've been asking for recommendations for a good commie liquor to drink during the show. Bad Vibe says, oh, so this one is relevant to our actual discussion. How does this apply to temporary insanity, like in the moment self-defense, where an otherwise rational individual is put into a situation where a threat escalates, but law enforcement refuses to intervene at any point? So I guess that would... I'm trying to figure out how to broaden this, but let's say hypothetically you've got a criminal defendant who pleads some sort of temporary insanity. Is there an immediate follow-up with an RPO? Have you seen anything like that? Can that sort of defense be used to then adjudicate them as unsafe for the purposes of a risk protection order?
I don't know. I mean, from a practical standpoint, I don't think that it really matters too much. I think people grossly overestimate how many people use an insanity defense.
Right.
It's rarely used, and it's even more rarely actually applied by the jury because the standard is just so high. It's really, I mean, with
much less a temporary insanity defense would be even a very small subset of the insanity defense generally. Because you basically have to get a health professional to analyze your behavior that they didn't witness, but they're getting either from your testimony or another compilation of facts, maybe a video, and then analyze your current behavior and suggest that at that time you are not in a proper mental state, but now you're just totally fine, bro, and everything's okay. It's a really hard thing to convince a jury that someone was a complete danger who is unable to make decisions for themselves for a period of like an hour or two, but now they're all good.
Yeah. I mean, it's funny to me because a lot of people think, oh, the system's got so many abuses and people get off on technicalities. Just look at the insanity defense. But jurors, they are not all about it. They even when somebody makes an insanity defense, they just don't buy it ever. Less than 1% of case, and that's all insanity defenses. Like you said, temporary insanity, even less likely. Now could law enforcement in that hypothetical situation come in with an RPO? Yeah, they've been doing whatever the hell they want to do, so it wouldn't surprise me. But
sure,
an outlandish.
Let's kind of focus back on the question I was asking earlier, or not the question, but kind of the subject I was asking earlier. Can you walk us through the process of an RPO from the moment sheriff knocks on client door to through a final order, kind of what that looks like, where you get involved, and then maybe even talk about because there are definitely some Floridians watching, Floridian gun owners. So if something, if the sheriff shows up at their door, what do they do? What do they not do? What's kind of the process there?
So it starts before you get the knock on the door, and that's just with somebody making a report to law enforcement one way or another. It's rare that the law enforcement officer just happens to meet somebody on the street who's acting a fool and decides that. So if somebody calls it in, maybe they see some online comments that they think are disturbing, and they want the police to follow up with who they think is potentially a school shooter, whatever it happens to be. Law enforcement takes a look at the evidence or takes the statement of the person making the report, and they go ahead and call up the judge, the RPO judge, and they say, "Hey, RPO judge, we think this guy is crazy. Can you give us an ex parte?" It's almost always a phone call. It's almost never in person. So law enforcement calls up the judge to get the ex parte order. That has to happen within 24 hours of the petition being filed by law enforcement. 99% of the time, the ex parte order is granted by the judge, and within 14 days, there has to be a final hearing. Now, that's always interesting because the 14 days is supposed to be in furtherance of the respondent's due process interests. Basically, you want to have that hearing very quickly so that if this was an erroneous taking, that you can go ahead and have that cleared up by the court. You can go in and present your case. But it also cuts the other way because by the time the person is in fact served, about 14 days is maximum. So by the time the person is in fact served, a lot of the times they only have maybe 5-6 days to prepare their case, which isn't enough time.
Sure. So
if you've got allegations by law enforcement. So.
Okay, so pausing here for just a minute. So law enforcement calls up judge, gets their ex parte order. So they then serve that order upon the person. You're suggesting it's about 5 to 6 days, maybe even up to almost 10 days that they're being served. And at that point, guns are confiscated. Is that how I understand that?
Oh, no, sorry. I should make it more clear. So they get the ex parte order from the judge, and that day they go and serve it on the person.
Okay.
They have to get personal service by the sheriff. So sometimes the person is still in a Baker Act facility. Sometimes they're in jail. But assuming the person is out, that same day they go and they get service as soon as they can. The hearing has to be within 14 days of the ex parte order. Okay. So some courts will, they'll set it 10 days out, and it takes a couple of days for you to get personal service on the respondent, and so they're really only left with a handful of business days to prepare their case. Yeah.
Gotcha. But law enforcement is attempting to serve these things as fast as possible. Right. It's just the nature of the logistically getting it to some clients is putting them out a couple some extra days. So, but if I'm sitting in my house, right, and someone makes a complaint and they say, "Hey, did you see this guy? He was drinking whiskey online and he says he has a gun at the bottom of a lake," which I know he means he's going to go shoot up some place. So I think you need to go check it out. And then they do an ex parte order on me. They're showing up at my door tomorrow if possible.
Right. If not in the middle of the night. Yeah. Sure.
Okay. So there's no timeliness restriction on this. It's basically treated as I don't know if there's a word for it, but like a high threat warrant. Like this is imperative. Yeah. It doesn't have to be done during normal business hours or anything like that.
Right. No, it's bumped up to the top of the list as far as calendaring for the judges. It's high priority. Yeah, it's even higher priority than domestic violence injunctions, which are, those are cattle calls. They happen every day of the week. Right. Everything but the RPO gets bumped in front of just about everything. Yeah.
Okay. Thank you for clearing that up. Okay. So ex parte order gets issued. Police attempt to serve this thing immediately. Confiscation occurs upon service of the ex parte order. Is there a weird scenario where confiscation can occur prior to service? Like if you're suggesting that they're in a facility due to a Baker Act hold where the police show up, there's an adult, maybe a spouse or a competent adult at the property, and then they can execute the confiscation warrant or seizure at that point. Is that how that works?
That happens a lot. Yeah. Okay. So I'd say in most cases, the gun is if the person owns a firearm, it has already been confiscated by the time the ex parte order is even being served. Okay. Most of the cases. Yeah.
Gotcha. So they don't have to wait for service to do the confiscation. They just have to serve at the earliest time possible.
Depending on the circumstances. So if somebody is being taken in for a Baker Act, that involuntary examination gives law enforcement the authority to go in and remove firearms.
Oh, okay. I missed that step. Gotcha.
Yeah, well, it depends. I mean, because if the Baker Act is the initiating event, then they might have already had that opportunity pursuant to the Baker Act to take the firearms. But if the person has their firearms taken away, like say they do something criminal, and so they're criminally charged, at the time they're criminally charged, then law enforcement can also take the firearms. And then the RPO comes afterward. Now, why they bother getting an RPO when they've already got somebody on criminal charges? I'll never have an idea as to why they would expend resources on that, but
Would that be
they do.
so? Now typically this doesn't happen where I'm from because I work in a small town. We're not talking about massive incomes for people who are being charged by the criminal justice system here, but typically in our criminal procedure, we have either unconditional release with bail being posted, or we have conditional release, and the conditions of the conditional release typically includes a prohibition on the ownership of firearms, especially for a felony offense or a drug offense, or even an alcohol offense a lot of times. So, do you think maybe they're just they're getting the RPO on the idea that maybe this person gets post bail and gets an unconditional release, or is that different in Florida to your knowledge?
To my knowledge, it's different here. To my knowledge, all of these people are most likely going to have some sort of pretrial conditions that restrict fire. I mean, unless we're talking about domestic violence misdemeanor or something like that. And I think even in those cases, they're going to have some sort of pretrial. So don't quote me on it because I'm not a criminal lawyer here in
Right.
Florida. But no, because I think, and I don't think that goes into the calculus at all, because so many of these people are already out on pretrial. So the person can't put in, or I should say, put on his or her own defense when they've been hit with criminal charges and an RPO at the same time. They can't go into the RPO court and say, for example, testify on their own behalf, because then they're jeopardizing their criminal case.
Right.
And so what a lot of people are doing is they're going into the court and saying, hey, Your Honor, the RPO court, I need an indefinite continuance because I can't do this RPO case while my criminal case is still ongoing. And what's it off the back of the law enforcement agency, because the temporary ex parte order stays in place while the indefinite continuance is happening. But
Sure.
but
It's just more of that wonderful innocent until proven guilty thing playing out perfectly.
Right. Or you could just stipulate to the order, which is what a lot of people do. They're like, well, I've got this criminal case and that's, my freedom is on the line there. So I might as well just stipulate
Right.
to the RPO, even though by the time their criminal case is over, it's already going to be a year on pretrial with no ability to access firearms anyway. But hey, state of Florida, you do you.
Right. Okay, I've got two questions and then I want to kind of get back into the process. Blaine 20 says, Floridian gun owner here. Do we yet know which side DeSantis lands on with red flag laws? Also, have we seen medical marijuana users being targeted for gun seizure?
I don't know exactly where Ron DeSantis stands on. I don't know that he's ever made his views on this public whatsoever as far as red flag laws. And I suspect that if it's politically popular, he's going to be all for it. And right now, these are riding a wave of political popularity among both conservatives and liberals. I mean, it's problematic because people really do like these. Well, they like the idea of them.
Right. I have I have family members who are wildly conservative, and have been for decades. But here's their thought process. I see mass shooting. I think mass shooter is crazy. I see law that says we take gun from crazy person before they mass shoot people, and that's the equation for them. And many of them aren't. I guess. They're not as deeply entrenched in the ideas of constitutionality and freedom that you, me, or many of the people in the audience are. So that's the end of their consideration is mass shooters are crazy. I don't want crazy people mass shooting. This thing takes guns from crazy people. But I would wager the large percentage of the RPOs aren't actually, and I know it's passed on the premise that it's stopping mass shootings, but these aren't mass shooters. These are suicidal people. These are people who are struggling with depression or some other neurological condition that might make them a risk to, and I have a high emphasis on might make them a risk to a domestic partner or someone else in their vicinity. We're not talking about people who are going to go blow up a library or something like that typically.
Right. No, vast majority of these people are getting the RPOs based on alleged suicidality or potential self-harm. Overwhelming majority of them. And then the next biggest chunk of people that I see who are getting these risk protection orders are stupid kids who said something in school or said something dumb online. And by kids, I mean late teenagers, early 20s. It takes a while for that frontal lobe to come in all the way. And so people say dumb things online, and there's this real culture of snitching, basically. It's if you see something, say something. And I think a lot of kids think that they're doing the right thing by turning somebody in to the FBI or to the local police. But usually it's just somebody saying something stupid online.
In that vein, this is a brief tangent. Have you seen the case? It's a federal criminal case where this kid was arrested, and the headline was that he said, "Kill all federal agents." Of course, the context of that particular comment. Now, there are several comments that he made, but that particular comment was he was discussing Waco, Texas, which occurred before he was born, and he basically said basically, if he were in the Waco situation, he would adopt the policy of killing all the federal agents. So he's commenting on a past event, and that commentary was used to affect his arrest. He's facing charges for threatening the lives of federal agents. Now, other statements, this kid may be crazy. I don't know. I say kid, he's like 18 or 19 years old. But other statements talk about him saying like the bombing of abortion clinics is just and within God's will and all of that stuff. So they've got a lot of that. But at some point, he seems to be making very politically charged and certainly inflammatory statements. But whether or not they rise to a criminal threat, I'm having a hard time believing that he's threatening people who from an event, 15 to 20 years before he was even born.
Yeah. And I mean, the Supreme Court still hasn't clarified whether or not a true threat has to have some sort of scienter behind it. Like whether you have to really intend to threaten somebody before you can be criminally charged with uttering a threat. And then you had the Alanis decision back in 2015 where they didn't really clarify it. So at this point, I think you've got a significant chunk of the court that wants it to just be not a reasonable person standard, but something along the lines of recklessness. Like if you utter something, even if you didn't intend for it to be a threat, that could recklessly be taken as a threat by somebody else, then you can be criminally charged. But all this getting back around to, I mean, in the RPO context, there doesn't have to be any scienter. There doesn't have to be an intentionality. There actually doesn't have to even be a target of the threat. The way that the law reads here in Florida is that it could be a threat against a property, a building. It doesn't have to be a targeted threat against a person at all. And that's good enough.
Now,
yeah.
Playing kind of devil's advocate on that, wouldn't they have a problem showing intentionality for someone that they're similarly or simultaneously arguing is mentally unfit? And then I guess that just led me to another question. How do they get around the idea of in a criminal case, you have to be mentally fit to stand trial, and they're taking away a right here based on the unfitness of the person, but similarly holding them fit to, I guess, stand some sort of civil proceeding. Do you have any comments on that?
Well, yeah, no, I mean, that's what's so interesting about it is it's not a mental health adjudication. So, it's almost like I keep on wanting to say the state, but that's a problem. It's not the state. It's actually the local police department or sheriff's department wants to have its cake and eat it too. It kind of wants to have it both ways with respect to, I keep losing my train of thought with my earbuds in. I can hear myself speaking. Hold on. Nope,
You could
I'm
do the one
completely
in, one
lost
out
it.
thing if you wanted.
Yeah, I think I might. Go back to your question, because then I might be able to pick up where I was going with that.
Okay, so the first part of my question is,
Oh, yeah, that's right. Temporary insanity. Oh, yeah. So it's not, I mean, it's never a mental health adjudication. So they're never actually delving into whether or not the person is competent or whether they even have a diagnosable mental illness. There's no expert testimony required at all. So they kind of want to have it both ways by using the concept of mental illness to take away the person's firearms, but not having to go through any of the hoops that you would normally have to go through to prove to the court, number one, that the person's competent in the first place. Number two, that they're actually demonstrably mentally ill. It's just all backwards.
sure. So then I guess that answers my follow-up question. If there's no adjudication of mental illness, then they can't. But it seems incongruent with the idea. Like, this person is mentally incapable of owning a gun, but they're mentally competent to stand
Right.
some sort of proceeding. And I think the state is really weaseling their way out of this by making this a non-criminal procedure. And in doing so, they eliminate so many of the protections that we would normally have. Gosh, I almost feel like, see, this goes to my personal animus towards the idea of civil infractions. That's one way they got around, like, the red light cameras and the speed trap cameras in some jurisdictions, is they said, well, it's just a civil infraction when it's a red light camera, so it's just a fine and it's not a criminal offense, and it does. But it's like, yeah, but you've just reduced your standard of proof for what is ostensibly a criminal act, and so that kind of bothers me on the surface of it. Nero says, this is going back to an earlier point where you mentioned that police aren't normally out there encountering these crazy people. Nero says that's an outright lie. And then I suppose Nero must be a police officer, says, I find people acting out like that almost daily just by doing my job and working in places you would never go if you were paid. So I guess that's...
I think Nero misunderstood what I was saying. What I was mentioning is that these RPO petitions are not usually arising out of law enforcement just happening to find somebody on the street who meets the criteria to have an RPO petition filed against them. It's usually happening based on the report of somebody who knows somebody, or again, if the law enforcement is actually encountering somebody on the street who meets the Baker Act criteria, that might be a situation in which they file the RPO at the same time.
Yeah, because they're typically going to be taking that person into custody when they encounter them. Like,
right.
if they determine this person is insane enough that they, or at least in a bad enough mental state that they need to be evaluated by a mental health professional, they're going to take them into custody and probably do the petition at the same time. But you're suggesting that the majority of these are not coming from that scenario.
No, I mean, no, I would say that the majority, like I say, the majority are coming from somebody. This is again why I think it makes no sense to have family members and friends be able to petition themselves. It's they're giving their tip-offs to the police. They're basically saying, hey, I'm worried about Billy. I think Billy is having a mental health crisis, or I think Billy wants to kill himself. Can you come do a wellness check? Or, hey, I'm worried about my ex-husband. I think he's, I just filed divorce papers and I think he's going to come kill me. And I'm too scared to go get a domestic violence injunction myself. But I think he's danger with a gun. And then law enforcement will go do its thing. But it's usually based on somebody giving a report and,
Gotcha.
That's my experience.
Gotcha. And then one more question, then I want to get back into that procedure sort of discussion we were going with. Anthony says, Kendra, I think I know who this is. As a paramedic in a county near your own, how would you recommend I interact with LEOs in regard to Baker Acts? They tend to do whatever they want, and it's usually bullshit, but I have to feed my family. What do?
I mean, I'm assuming this is not somebody who's interested in filing an actual internal affairs complaint. As far as, dealing with cops, that's up to them. Did he say he was an EMT?
Yeah, he's a paramedic.
I don't know. I mean, it depends on the cop, but usually if you try to tell a cop that they're doing their job wrong, especially when you're telling them, hey, you're not following the law, it never really seems to end well. It's just my experience with cops.
They're not very receptive to that.
But I totally feel you. And yeah, just thank you to him for being an EMT. It's not an easy job.
Yeah, absolutely. Absolutely. Okay, so kind of getting back into the procedure that we were talking about before. So we got to the part where an ex parte order is issued, confiscation occurs, and the ex parte order is served. And then you said within 14 days of the service, or no, 14 days of the issuance of the order, not the service of the order, they have to have a final hearing. What goes on in that final hearing?
Well, in most cases, I'm asking for a continuance because I need more time to get things like the body camera or to do depositions or otherwise engage in discovery if I'm so inclined to do discovery. It might be a situation where I just don't think much discovery is necessary. So I'm usually asking for a continuance of at least a couple of weeks. But let's say we're already at the final hearing. I've subpoenaed witnesses. Sometimes I've had my client do an actual mental health examination, and I bring that evidence into the courtroom. A lot of times, if I'm going to do that, then I have to file a motion to seal the proceedings because there's no confidentiality of these proceedings whatsoever in Florida. And I'm not going to put my client's mental health records out there because my client didn't put his or her mental health at issue. It was the police who put mental health at issue. But we're in an unfortunate position where the courts aren't so much having police bear their burden. It usually is my responsibility to prove my client innocent, frankly, because once police come to the courts with these allegations, it's an uphill battle. The courts want to believe police,
Yeah, I've talked about the law enforcement bias being, in my opinion, it's the hardest bias to overcome in a courtroom. Police officers are believed to be experts in human behavior. They're believed to be experts in the nature and use and testing of all drugs. They're thought to be experts in all aspects of firearms and everything. And I'm not saying that police are not knowledgeable in many, if not all of these fields, but they are treated as if their experience in the field gives them the expertise, which it may or may not do so. And overcoming that it's a Herculean task because you have to convince a jury that or even a judge that the person who might show up to protect them in a situation might not be competent to make those decisions. That's a tough thing to do, right?
Yeah.
But okay, so you do have the power to subpoena witnesses and bring them in on your behalf. And I suppose with a civil proceeding, you almost have to do this in that way. Whereas with a criminal proceeding, one of the things I like about criminal law is the prosecutor has to do so much work and the defense doesn't have to do as much until the prosecution puts forth, and they have to disclose it ahead of time, puts forth a pretty useful case. You can go in and argue that, hey, judge, they don't have anything here, but you can't really do that in your case because you said it's clear and convincing evidence, but it sounds like it's barely preponderance in practice.
Yeah, barely. I mean, in the way that I see judges applying it is basically on a better safe than sorry standard. Like if there's any remote possibility that you could conjure a hypothetical in your mind that this particular person, even if it's 6 months from now, might have a bad day. If it's even feasible in your mind that this could happen as a judge, I'm just going to go ahead and grant the order because I would rather grant it and be wrong than not grant it and be wrong, right? What if this guy does do something and I didn't grant this risk protection order? Then everybody's going to be pissed off at me.
Right.
And so, yeah, the clear and convincing evidence standard is bullshit. It's not what's being applied. But the bigger problem really is you've got a list of 15 supposed criteria that the court may consider. It's optional. They can consider all of it and still not grant the RPO, or they can consider none of the criteria. You know, really, when you get right down to it, it's like a whole bunch of the criteria might as well not be on there. I mean, domestic violence injunctions. If you already have a domestic violence injunction, you already have a firearm prohibition.
Right.
Some like domestic violence injunction arrests. Well, if you already have that, if you've got a conviction, then you've already got a lifelong ban. A lot of it is just kind of to give the illusion of having some sort of set list of things that the court goes by. But at the end of the day, the actual standard that's being proven is whether somebody is a significant danger based on any relevant evidence. And that's not a standard at all. Number one, the term significant is inherently ambiguous.
Right.
It can mean, like clinical significance, just enough to be noteworthy, or it can mean like a whole bunch.
And are there is there conflicting jurisprudence on that right now over the ambiguity of that phrase? And is the court trying to address that, to your knowledge?
Well, there was the first appeal that was handed out to one of my colleagues in the First District Court of Appeal here in Florida, which is the northern part. It's Tallahassee and Jacksonville.
Sure.
And so that's the court that recently held that the red flag law was constitutional and made this just atrocious. I mean, there wasn't really any argument there. They just said, yeah, strict scrutiny applies and this meets strict scrutiny. And it's not vague. They actually said that it's not vague because the word significant is not vague at all. It's no more vague than the word imminent. And it just means the opposite of trivial. Now, if you can tell me what a trivial danger is supposed to be versus a significant danger, I would love to hear it, because I don't think that anybody actually knows. Even if we frame it as like the opposite of trivial, you still have no idea what we're talking about.
Right. So. Imminent has a meaning. It's right now. I mean, the idea of courts have been, the imminence standard has been around since at least Brandenburg. So we've got 50 to 60 years now, almost 70 years of kind of refining what imminence means, and it's always meant imminent. It's meant that it's going to happen within the foreseeable future, as in if you left the area to get lunch and came back, that's beyond imminence. We haven't even similarly expanded imminence to mean well, it would take this person an hour to drive there, so it's still imminent. Actually, I think the court has specifically held that is not imminent. It means presently possible. Suggest that significant is anything close to imminence is nonsense. That's kind of sad.
It was very disheartening, really, because I mean, not to beat a dead horse, but imminent, it's not the same as saying, okay, exactly 5 hours from now. But you can put a finger on it. You can kind of figure out what imminence is supposed to mean, even if it's not pinned down exactly. But significant, I mean, to claim that there's nothing vague about the word significant, it's kind of mind-boggling to me. But you actually already have federal cases out there that have expressly found that the word is inherently ambiguous. So I am hoping with the appeal that I've got going, where I've got my oral argument on the 22nd, that I'll be able to have a better time making my argument that this is a vague law.
And you're not in the first district.
No, the first district is the one that just ruled, and then the one where I've got an appeal is the second district, which is the Tampa area. So Tampa, Polk County, that's just a little bit west of Orlando.
Sure. So then, assuming they do rule differently, we've now got something that's ripe for a Supreme Court challenge. If they rule in your favor, it's almost guaranteed that law enforcement is the state is going to push that to the Supreme Court. Do you think that this goes beyond the Florida Supreme Court? Is this a U.S. constitutional issue? I mean, to me, it clearly is, because it does implicate an enumerated right. under the U.S. Constitution. As I assume the Florida has some right to bear arms in its Constitution as well, but we're talking about this has got to go to the Supreme Court.
Yeah, and it's a matter of, who's going to have the right appellant at the right time.
Right.
And so I've gotten a lot of people reaching out to me saying pretty much, what can I do about it? Well, beyond contacting your legislators, and that's both at the state level and the federal level, there isn't a whole lot that you can do. I know that some people want to bring, pre-enforcement declaratory actions. And I'm pretty much like, no, you really do need to be the right sort of appellant in order to be successful. It's why, it took years to find Heller as the perfect plaintiff in the Heller case. And
as the cop with the gun disassembled, just not locked up or whatever it was, it only would have been better if it was like a church lady serving sandwiches at the time. But right, it really does matter because despite the fact that justice is blind, if your client is in jail for some other offense at the time that they're RPO'd because they're accused of beating their spouse or something, and then they're RPO'd, and even if they clear themselves, there's still this lingering accusation that this person might have been beating their spouse, and that's something that's going to play into the minds of the appellate justices and of Supreme Court justices, because it's also going to be on the mouths of the media, right? Like that's just something we have to consider in this, and I think people kind of miss that fact a lot. One thing I wanted to circle back to, and this gets into that domestic violence sort of idea, is one concern that Minnesota has tried to address lately with criminal proceedings is that the criminal proceedings they're not carried out under seal, but they're not publicly and widely available until a conviction occurs. You can go into a specific courtroom or courthouse or onto the court website at the courthouse, and you can pull documents from an ongoing criminal proceeding because they are ostensibly public. However, if I try to log into the court records from home, I cannot see an ongoing criminal proceeding. And the idea behind that is they don't want an employer sitting at their desk pulling up a criminal record and making an employment decision. But these are civil proceedings, right? Is there concern that people will abuse this for the purposes of harassing a person by putting, could you imagine if there was a coordinated effort to report someone and have RPO proceedings maybe amongst 3 or 4 people every 2 months or so, or for a 6-month period, then that would always be there, right? Like there's no expungement of the proceeding, only the idea that they're cleared of it, but the stigma remains. Is there any concern about that?
Well, I think for a lot of my clients, obviously the ones who don't have firearms and have never owned firearms before, the collateral legal consequences are what concern them. And it's not just the ability to go to school, for example, because I've had clients who are nearly kicked out of school, but professional licensure, employment. What people need to know is like, okay, the way background checks are done nowadays, it's usually through a third party independent. It's not through the state actor that actually is the records custodian. So the moment that every county uploads its mugshots, et cetera, there are all these private databases that are going out and getting all of this information. And they now sell that to employers, whoever needs to do a criminal background check. They're getting their data actually from these third parties that are using privately held databases and information that were gleaned from state records. So even if you were able to actually expunge, and I have clients this happens to all the time, they go through an official expungement or a sealing of their criminal record, but then a couple of years later, they're applying for a job or a loan, and they're told, hey, what about this XYZ, this domestic violence arrest that you never disclosed? And they'll say, wait a second, I got that expunged. How are you even finding it out? Well, they're finding it out through these online private databases, which is where all the criminal background check information is coming from anyway these days. So I think it's become sort of a moot point as far as the expungement thing goes. But the fact that these are completely public record, there's no sealing, there's no expunging. I mean, it does, it's potentially going to impact people for a really long time in a lot of ways that I don't think anybody ever anticipated or expected or thought about. Yeah.
Absolutely. Yeah, I mean, there are the potential. This is what concerns me, and you brought this up earlier. Our culture has our current culture has this idea that snitching is the right thing to do. See something, say something, go to the authorities immediately with anything. And I think a lot of that is propagandized on the popularity of the mass shooting or something like that. But we see that emotionally being used to turn ourselves against our fellow citizens. But this goes beyond just the gun thing, right? We see people being canceled from all sorts of things over words or dangerous opinions, almost on an alarming basis. Almost daily, you can find a story about someone who said something wrong at some point in their life, and that is unforgivable, and they must go. So I think you're spot on that people are not perceiving the risks to something like this. I have another question for you. This is from Bad Vibes. Well, it's more of a comment. It says, this sounds like the same thing as the state holding minors accountable as adults in spite of the, quote, not understanding the consequences for their actions, hypocrisy. So I guess that's talking about mentally unfit people there. But you mentioned you're a civil rights attorney. I did have a question earlier from a viewer who was curious on your stance of like sex offender registries and whether those sort of comply with civil rights, if they're offensive to civil rights, if they're on the right track, but if they need tweaking. What do you think about that idea?
No, I'm 100% against sex offender registries. I think that they're ineffective. But this is just from the practical standpoint.
Sure.
They've been shown to actually make communities less safe. And what else would you expect? You've relegated somebody to second class, third class, fourth class citizenry. And they can't make an honest living. They can't actually find any place to live. It's just a way to breed more crime. So they make no practical sense, but they also don't really make any sense from a public safety perspective either, because this entire, not just the registry, but also, indefinite civil commitment, like the Jimmy Rice Act stuff. This is all based on misapprehension of fact that happened back in the early aughts there. So McCune v. Lyle was this famous case from 2002. I think it was the Alaska indefinite civil commitment case. And that's the case in which, I think it was Kennedy, I could be wrong, said that the recidivism rate for sex offenders was frightening and high. Something around 80%. Well, it turns out that wasn't true, but this line, frightening and high, 80% recidivism rate, got passed down. And when you combine that assumption of fact with another assumption of fact, which is that psychiatrists can accurately identify who these people are, who are sexually violent predators, who are likely to reoffend. So you take those two facts together, and we'll start creating registries, and we'll start putting people in indefinite civil commitment lockup, potentially for the rest of their lives. And we'll start loosening due process. We'll start allowing in hearsay, all of this stuff. It's all based on factual misunderstanding and a lot of hysteria too. So yeah, I find it troubling.
Yeah, I'm torn on the issue because I've seen the alarming and high recidivism rates. I've also seen data that suggests that the recidivism rates are lower than they are for other types of crime. And when you have these charged issues and you have interested parties on both sides, I find that it's hard to parse out which of the data is valuable and which isn't. But I do find it to be an interesting thing. And obviously, current topic, sex offense is just such a prominent sex offense, sex trafficking, pedophilia. These are such prominent topics right now. I almost find like it's useful to couch the discussion in another but similar area. And one that you've brought up here, and this is, gosh, I can't remember what federal law this is called, but it was an act of somebody who was killed, but it basically prevents a person who's charged with a felony or a violent misdemeanor, specifically domestic violence misdemeanor, from ever owning a firearm in the future. And that seems like an impermissible intrusion on our Second Amendment rights. So I was curious if you had any. We can kind of move the discussion out of the charge nature of the sex offender registry and into this idea of how long do we punish people for a particular act. And
Right.
and I wondered if you had any opinion on the idea of saying that someone's Second Amendment rights are revoked forever if they say spit on a spouse, because that's a misdemeanor domestic battery. Do you have any kind of opinion on that?
Yeah, I find it. So I don't, in theory, have a problem with people who have a domestic violence injunction being prohibited from purchasing or possessing firearms. In theory, the problem that I have is that it's so easy for somebody to get a domestic violence injunction that you've got a whole lot of abuse of the system going on. And I see it in like family law cases where basically the one spouse is trying to get an upper hand in the
Yep.
family law proceeding. And then they tell a sob story in court, and all of a sudden somebody's got a domestic violence injunction. They've had their firearm rights suspended. I find that really problematic. I think that the only way you fix it is to heighten the burden of proof in domestic violence injunction proceedings. But I think that until you do heighten that burden of proof and make it much more difficult for somebody, actually, until you make it impossible for somebody to go to court with only their story and no corroborating evidence and no witness testimony besides their own claim that they were abused, then I think it's troublesome, to say the least, that we've got the federal law basically saying that with any sort of domestic violence injunction or now misdemeanor conviction, that you can have your firearms rights suspended indefinitely or forever. Misdemeanor convictions for domestic violence injunction, I think that's also problematic just because you've got, every state has its own definitions of
Right.
what actually falls into these categories. And so arguably you have an equal protection problem. But I don't know that anybody's made that argument in federal court yet, so could be wrong.
Yeah. Are you saying because the equal protection problem would be related to the rates of domestic violence charges on men versus women? Is that what you're going with there? Or?
No, more on the lines of the way that it's, and I maybe don't quote me on this, but the way that the term domestic violence is defined from state to state for the purposes of securing a domestic violence misdemeanor conviction. If it's being applied too differently from state to state, and I don't know that there's a federal definition that they all have to meet. I'm pretty sure it's still left up to the states.
I would think they'd be hesitant because it encroaches on family law, which is like the last bastion of law that is reserved to the states.
Yeah, so I think without that standardization from state to state as far as what constitutes a domestic violence misdemeanor conviction, I find it troubling because I really don't think that this is a matter for federal law to begin with. So
I think people may not understand that in Minnesota, for example, if you are in college and you get in a fight with your roommate and you are charged for that fight, that's domestic violence conviction. And so if you're 21 years old and you get hammered and start punching your roommate because he's playing World of Warcraft at 4 a.m. or whatever, that's it. You will never own a firearm for the rest of your life unless you can somehow get that conviction expunged, which is really difficult to do. I believe it's actually impossible to get a domestic expunged in Minnesota. And then even if you do manage to get it expunged or even a pardon from the governor for it, you then have to petition ATF. And ATF just isn't a happy group of people handing gun rights back to people who have lost them. That's just not something that they like to do. But it's pretty insane. What when you're talking about the state to state distinction of what a misdemeanor domestic violence act conviction actually entails, it could be very broad.
Yeah.
Or if you punch your landlord, because some landlords suck. No, I'm joking. I'm not joking. Actually, in Minnesota, that is a domestic as well. So, I had another big constitutional hypothetical for you, and I lost it. That stinks. Venomine says, "Love you, Kendra. Hope you're open to more streams in the future." I do want to suggest that I would love to have you back on at some point. Not that we're done now, but I'd love to have you back on at some point to talk, I guess, more broadly with maybe a panel of people about the Second Amendment and how the courts have, I guess, interpreted this. I remembered my question. It was, do you think there's some sort of value in these domestic sort of disputes in raising the burden of proof on a private petitioner to something similar to beyond reasonable doubt, in the event that we're implicating, or that we're employing the court to implicate a enumerated right? Is there an argument there? I almost feel like we've done that with something similar with voir dire when it comes to jury selection and dismissing people based on an inherent characteristic such as race or sex or something like that the court is then required to apply the level of scrutiny that you would apply in discrimination on that dismissal. If I'm remembering that right, I don't actually know if I am. But
yeah, it's beyond me. That's a topic I don't know about. When it comes to, here's how I feel about it, big picture wise. I think risk protection orders are probably here to stay in one form or another. I don't think that the courts are ever going to find them blanketly unconstitutional. So they're going to be around in one form or another. And the way that you can actually mitigate the impact, especially the impact on people who are falsely accused or definitely not a danger to themselves or others, is to actually put in minimal procedural protections. That means appointing counsel to people who can't afford it, which is a huge problem right now. People are not getting appointed a lawyer. This is what the ACLU actually made a big stink about when Rhode Island was going to implement theirs. And the ACLU pressured Rhode Island into making sure that people got counsel when they were being charged with these RPO petitions. So
right, because you only have a right to an attorney under the Constitution, a Sixth Amendment right to an attorney under a criminal case. You don't have one in a civil case, even when the opposing party in a civil action is the state itself, which is, again, that's just that concept alone is insane to me, that the state is engaging in civil actions against its citizens.
But see, there are certain civil actions that do require the appointment of counsel. So an involuntary treatment hearing for involuntary mental health hearing, that requires the appointment of counsel. Termination of parental rights requires the appointment of counsel, but it's not pursuant to the Sixth Amendment. It's actually pursuant to the 14th Amendment due process clause, right? So
right, the idea that they're, oh, sorry, I didn't mean to go on.
No, it's fine. I was just going to say, and that's what I've been trying to convince the courts of, but so far they haven't.
And in those 14th Amendment due process clauses, we're arguing that the state action in this case does implicate a fundamental right in the terms of involuntary confinement, obviously the right to liberty, and then one of the most preciously regarded rights by the courts, at least in their words, is that of the parent-child relationship. In almost every state, that is true, that they at least say that this is one of the most sacred rights, and so therefore the termination of those parental rights is involves the implication of an inherent right, which is weird that they treat inherent rights almost differently than enumerated rights sometimes, because there is no constitutional right to parentage. Right. But it's so default to the human condition that we assume it to be true. But yeah, that's really interesting, and I wish you a ton of luck in that, because that's something I hadn't even thought of, that as these are civil proceedings, and this is something I talk about from the criminal aspect, is that the burden on the person to hire competent counsel is, for many people who are involved in these situations. You're talking about someone who is, let's not mince words. This person is bordering on somewhere between mental competence and mental incompetence, right? This person is, if not incompetent, typically not well adjusted, I would assume, right? Like that's the majority of cases that you're seeing. Is that fair? Maybe you don't want to say.
No, I've had an interesting mix of people, a couple of minors, late teens. I've actually had 4 different members of the military, all, I mean, I don't want to say perfectly normal, just because I don't even know what the hell that means myself.
Right. No, I get you.
Well adjusted.
Sure.
And I've had two people who were security guards. Now, one of them was kind of an eccentric fellow. I mean, we won both of those cases, fortunately, because otherwise their careers would have been over. But no, I mean, I've been finding the people who have been coming to me, invariably, they said something stupid. They had like a bad night, and they said something along the lines of, I just can't take it anymore, or I don't want to keep living like this. And it snowballed into an RPO. So.
Right. And well, there's a greater argument to be had about the implication of mental health laws on, specifically on armed servicemen, because we have some level of benefits being tied to something like post-traumatic stress. And so there's a concern there that if these soldiers are collecting benefits for what they went through based on some post-traumatic stress, and that post-traumatic stress doesn't necessarily mean that they're a danger to themselves or others. It just might mean that certain events trigger them and cause various issues with employment. In particular situations, that the acceptance of those benefits would require them to basically tell the state that they're mentally unfit to own a firearm, which is that's a huge risk. And people with PTSD can be very well adjusted outside of very limited specific circumstances that relate to their traumatic stress. So there's what I was trying to suggest is that whoever is reporting these people, for whatever purpose, has determined that they are, at some point, they are not what we would consider well adjusted, at least in the moment. Either they're having a suicidal thought, or they've made some threat, or even just said something stupid. They're on the border between that competence and incompetence, and some of those people have issues with employment sufficient to hire an attorney. Because you mentioned that these are, on their face, it's a 14-day proceeding, so it should just be, okay, I hire an attorney for one hearing. But it's a civil hearing. You may have depositions. You may have to subpoena witnesses. I assume these hearings could be multiple hours long. We're talking about thousands of dollars. Certainly the fees can rack up very quickly. And that's just inaccessible for people on even a median wage a lot of times, especially if they have a family to support and something like that. So I think that's a huge issue. And I'm glad that there's someone fighting over it, because I hadn't even thought about it.
Yeah, because I mean, it's not only an issue from the standpoint of, it's not a fair fight otherwise, but it's also an issue just because I think you'd have a lot fewer frivolous petitions being filed in the first place if they knew that it was going to be a fair fight, if they knew that they were going to have to subject their allegations to the light of day, and to another attorney who knows when to make objections and preserve, a good record if necessary.
Right.
Because it's definitely not a fair fight as things have been happening. I mean, in a lot of instances, the general counsel for the sheriff's department or the law enforcement agency will basically intimidate the respondent into stipulating to the order by saying, hey, you don't really want to have to go to court. I mean, it's going to be us against you. Wouldn't you rather just sign away your rights and then, you don't have to go before the scary judge? And a lot of people have been sufficiently scared by the idea of having to go to court by themselves that they just went ahead and signed away their Second Amendment rights, not wanting to, but.
Yeah, and there's a whole wealth of people out there with an inherent distrust of the court process and of judges. Particularly you're talking about areas with severe crime problems, and I'm talking about like localized crime problems where their friends, their family members have gone to court and end up in jail. These people don't trust the judge to be an impartial observer. Their life experience has taught them that person is very much partial against who they are and who they know. So it is actually really a short bridge to walk, we'll suggest, for law enforcement to say, hey, you don't want to go through this. You saw what happened to your brother, your cousin, your uncle, your friend. They went in, they said the wrong thing. They ended up in jail from this. We can just get rid of this if you just go ahead and sign this type thing. And you don't want to go through this. And before I get heat on that, not all cops are like that, obviously, but there are undoubtedly law enforcement agents who work in that way. And I've met them. So, I'm sorry. I just have. Okay, so here's a question from the chat. DOG Beera says, what is your opinion on universal reciprocity and its impact on federal versus states' rights? And then the follow-up question is, what type of dog do you have?
I'll start with the last question, which is, she's a corgi mutt. I'm sorry, I can't get her to come over here. She's sleeping right now. So she's a corgi mutt, and I got her at the Humane Society almost 6 years ago. And she's my constant companion.
Corgis are best boys.
Oh gosh, she's such a good boy. Yeah. But it's interesting. I don't know. I like, in theory, the idea of reciprocity. And then on another hand, I guess it does sort of offend my sense of federalism, and whether or not that's an appropriate encroachment. It creates a race to the bottom sort of situation where eventually, if you've got that kind of reciprocity, you're just going to eventually have nothing but the weakest,
everybody's licensed in Oklahoma, basically.
Yeah, exactly. And at that point, is there really any reason for licensure to begin with? I do think states should have the authority to impose their own licensing rules if they want to. That's up to the purview of the states within reason, as long as it's not encroaching. I would personally be in favor of better training requirements for certain individuals. A lot of these individuals who teach the courses don't require much of their students in order to get a concealed carry permit here in Florida. So, I think people should have to show like a minimum competency instead of literally just shooting into a barrel a couple of times. But it's a hard question. Would I prefer that things be as they are now or have reciprocity? I would certainly prefer reciprocity. The main argument I find in favor of reciprocity is we enforce reciprocity, or at least accept the idea of reciprocity in pretty much every other avenue, including things that are distinctly not fundamental rights. For example, driving. There's universal reciprocity on a driver's license, even though driving is not a fundamental right. It is over and over referred to as a privilege in jurisprudence. But I guess that's within the state's ability to do so. Although I feel like, is there a federal enforcement of license reciprocity under the Highway Administration? That's a good question.
I don't remember. I just know that they did so much in the 50s when they built the U.S. interstate system. That's where we got the 21-year alcohol age in all states. Was they just made highway funding contingent specifically on that, and then the federal government won in kind of a surprising case where they suggested that it wasn't a coercive amount of money, even though it was like all of
Yeah.
it.
Yeah, I think I know what you're talking about. Yeah.
But
Uh,
yeah, anyway, I just that's my main issue with reciprocity is with Obergefell especially. We have enforced reciprocity of marriage licenses that some states had overtly denied, and right or wrong in that state, they had done that. And then the federal government comes in and says, no, you have to recognize the validity of this licensed activity within your state that your state has been free to define up until 2015. But here we have, again, a fundamental right that's enumerated in the Constitution. And we say that there's no enforced reciprocity on that. Although I guess technically licensure for a carry permit isn't the same
yeah.
as keeping and bearing arms. But then I guess my follow-up question to you is, so you have some instances like the Ninth Circuit where they determined that acquiring a concealed weapons permit is so obstructive and difficult that everybody is entitled to open carry, whether or not if they don't have a concealed permit. What do you feel about that issue? I guess where we decide that you either have to have a concealed permit process or you have to be allowed to open carry or something like that. Is there a balance, or do you have any opinion on that matter at all?
You know, I've always found open carry. I don't see that. Maybe I'm biased because I've been in Florida for so long, where we basically only have concealed carry.
Sure.
But I've found open carry, especially in hot political climates like we're experiencing in the past couple of years, to be counterproductive. And this isn't a matter of could we do it pursuant to the law, of whether it's prudent, basically, because you give gun grabbers a whole lot of ammunition, pun not intended, to go online and start fear mongering by claiming that they're worried to step outside because they don't know whether the next person who's open carrying is going to be the next person to shoot them up. And so, oh my God, woe is me, the fear, the fear. So, just from a personal preference standpoint, I think concealed carry is smarter, politically and from a safety.
Concealed carry, there's a lot of argument out there, even from firearms instructors and stuff like that, that concealed carry is preferable because you're not an identifiable target.
Right.
To a particular shooter. Now, personally, though, this infringes upon my right to wear a Gadsden flag loincloth and just a bunch of guns strapped to me for Halloween. That's what I want to do with my life. But
no, I don't think anybody. Well, come to Florida, you'll be right at home. We'll
perfect.
Just put it that way. Yeah.
I'll be there later this year, actually. So, and actually, I think I'll probably be in your area. I should stop by. We should have a whiskey or something.
Just that.
Yeah, I don't. I do see the problem with that, right? Like you've got people who don't understand firearms coming out on national television talking about like fully automatic ghost guns and stuff like that are undetectable. Yeah. And then, of course, the counter side of that is a 250-pound guy in a cowboy hat and underwear with like 9 ARs strapped to his back for the simple purpose that he can. Yes, he can, but does it mean that he should? And does that help the public debate? Typically, no, I would think.
Yeah, I mean, I think that there isn't really any good evidence because there have been cases about this. Like, for example, Florida is only concealed carry. So there have been challenges to the fact that you can't open carry. And they're always upheld by the state's highest court or by the federal courts. Oh God, I keep losing my train of thought. Jeez. But in any case, I think that there's no good evidence as far as whether or not one is safer than the other. So I don't think it makes any sense to bring up that argument. I think the best argument you make with respect to laws limiting one or the other, whether it's open or concealed, is that one is just more practical than the other. That's all I can fall back on when it comes to that question.
Sure. This is Nova Zero is responding to my statement that that it's insane that the state is engaging in a civil action against private citizens. He says, "Hey Nick, it's not so insane. I don't think you want the image of a private citizen going out there to duel the entire state." Jokes aside, I second the other Nick Love. Kendra, please come on the show more. So,
I will. Yeah.
S. Cyber Taz says, how would an RPO work with a criminally negligent law enforcement officer like Sheriff Scott Israel and the Nicholas Cruz / Stoneman Douglas shooting when they ignored 40 plus calls to the FBI and local law enforcement? Why does he even still have his job? That's a loaded question.
He doesn't have his job anymore. Pretty sure he's not in there. I think they still I can't remember the guy's name, the replacement, but Ron DeSantis basically kicked Sheriff Israel out of the job. He has intimated that he might run for office again, but for now he doesn't have a job. And I think that the I don't know whether I want to say the caller, the writer, whoever's made the comment, is hitting on a really good point. And the point is this, like, a lot of the people who have been in favor of red flag laws have said that the reason that we need them is because if we'd had a red flag law, then we could have prevented something like Cruz from happening. And that's just an unmitigated load of hogwash. It's hand washing, because as the caller noted, there were plenty of warning signs. There were plenty of laws that could have been used. They just weren't. So the idea that we needed a red flag law in order to stop Cruz, the idea that we didn't have laws on the books that could have stopped him, is just not true. And I think we need to stop using it as a justification for laws like the RPO laws, especially because whatever evidence there is out there, there is certainly no evidence that they prevent mass shootings. That's, there's no evidence whatsoever for it.
Right. And one of the things I was talking to you about prior to the show starting was the idea that, in my opinion, the red flag laws miss the purpose because they aren't quite imminent enough to be back to that word imminent. If you think someone's a mass shooter, you don't want to petition a court, have an ex parte order issued, and the police go and try and do this. If you think someone's about to go shoot up a school, you want to call the police, say, I think this person's about to go shoot up a school, and have them show up right away. You don't even want the minor inconvenience of a phone call with a judge to be in the way there. You want them to prevent the imminent act. And in my personal opinion, if the act isn't imminent enough to warrant the police intervention, then we don't know that the act is going to occur in the first place. That's like saying, I think this person might beat their spouse in a week or so, so we need to rule on that. It's like, well, if they're going to hurt their spouse, I want that to stop prior to it happening, and prior to it happening now. If they're not going to do it now, we don't know that they're going to do it tomorrow, type thing.
Yeah, and I mean, that kind of, it reminds me of how arbitrary this year-long period is. This is just what it's developed to be, but the RPOs are for a year. It can be fewer than that or fewer months than that, but 12 months is basically how long we're doing it. Well, how do you even enunciate a standard that's basically alleging that a person is a significant danger of potentially, hypothetically, possibly committing some sort of violence at some point in the next year? Right. Maybe. I mean, it's just, you can't even make a standard that makes sense out of that.
Do they have a renewal process for the RPO that's a reduced sort of standard? And for example, in Minnesota, if you get just a normal protective order in, say, a domestic situation or a family violence situation, they last for 2 years. And then the petitioner who has the protective order can petition a court again within that 2 years for an extension. And the court tends to basically look at it and say, did they do anything at all to improve their situation? And if they didn't, they're going to extend it. They're going to say the person still has a reasonable fear if they didn't enter some sort of anger management or complete a treatment course or something like that. They're going to go ahead and extend it because, of course, they would. Why would we suspect that this person who hasn't made some sort of step be less dangerous now than they were 2 years ago? And I understand that's logically not necessarily true, but that's how courts treat it. Is there something similar with RPOs in Florida? Where like say at 12 months or 11 months, they can do a petition to renew for another period or even push for a permanent injunction.
Yes, no, there is that, and it has to be within 30 days of the expiration of the original order. But going back to your question, as far as whether or not there's a process where their burden is reduced, there actually is, but only if it's an uncontested petition to re-up. So say you've got the order expiring in 30 days, it's about 20 days to go. They go ahead and file a petition, and the respondent doesn't protest the petition, then on the word of just an affidavit of one of the law enforcement officers, based on personal knowledge of the law enforcement officer, they can basically say, none of the circumstances have changed, and so we would like you to just go ahead and enter the order in for another year, Your Honor. So it does exist. I haven't seen it used yet, but
I'm curious when it is used, if that personal knowledge will be literally, I looked at the file again for the first time in 11 months and I don't see any reason to change it. Cause that, I mean, and I've, full disclosure, I've used that in a domestic protective order here. And the reason is because it was true. The person who was restricted, who was, we had a protective order put in place because the person was demonstrably abusive. And then they were given an opportunity by the magistrate to enter counseling with the victim, supervised visitation with the victim and stuff like that to try and rebuild a trusting relationship. And all they had to do to get their 2-year order knocked down to 6 months was make a phone call, and they didn't do it. So we figured that was enough assertion to suggest that this person had no interest in remedying their behavior. They were just going to wait out the time limit. So I'm just curious. I find that to be very different when it's a private party acting than when it's the state acting. And that's where I draw the line. And plus we've got a fundamental right being implicated here by the state itself. So that's pretty interesting. Perception Check says, I'm definitely going to have to go back and watch the rest of the stream of what I caught of it. It's been very interesting and educational. Good palate cleanser, Nikki. You should invite Kendra on for a big brain panel. Maybe, if you'd be interested. A big brain panel.
I don't know what that is. But...
Well, I was going to explain it. It's where a couple other lawyers come on the show and we all get really drunk and have a panel discussion, complain about stuff. And eventually it's just us like yelling at the audience, like, you don't understand. They're a lot of fun. George Lopez says, here's a shout out to all the judges in the chat. On another note, Nick, the military has enough to protect the Constitution from all enemies, foreign and domestic. Sorry, this is the largest super chat I've seen in a while. Funds. Don't worry, you never have to apologize for a super chat. I appreciate all of it. I do have a question for you. And then we can start to wrap up the stream after this, because I know it is very late where you are. You're an hour ahead of me. But what is your opinion on the issue of the 3D printed guns, and how do you think that's going to impact an RPO? Because if I can 3D print a lower receiver in my home, that'll fire through. I mean, they've got those things pretty sturdy these days. If I can 3D print one and then the rest of what I own isn't a firearm under the law, is there going to be an RPO that has confiscation of the printer, or how do they deal with that? Do you have any?
Oh, well, I think it's actually the same question that we have going on right now with respect to private sales and transfers. So an RPO isn't going to affect a private sale where there's no background check that's done. And this is what a lot of people are talking about when they're talking about closing the quote unquote gun show loophole, is that, what good is it to have an RPO scheme, for example, if a person can still just complete a transfer in a private sale and potentially not go through a background check? Well, number one, almost all of the vendors that I know of, they do background checks. They don't want to expose themselves to the potential liabilities of not doing them. But go back to the way that you framed your question, because I was about to segue into my answer directly to you, and now I've completely forgotten again.
Okay, so does the 3D printed gun pose a problem with RPOs?
So yeah, no, I mean, whether you're talking about somebody being able to get a firearm because they can print it, or somebody being able to get a firearm because they can get it from an illegal source, I think is really the same question.
Right.
You're never going to be able to get around it, right? You're never going to be able to prevent people who are intent on doing bad things to other people from getting a firearm or getting some other weapon to do what they want to do. And so this is what law enforcement does, right? They implement a lot of security theater, which is what this is. It's not keeping anybody safer. It is security theater. And then basically playing whack-a-mole, with individual instances and, hoping to keep politics at bay. But,
Right. I just keep wondering if what they're going to start doing is then you're enjoined from owning any firearm, and also any sort of material that would, or any sort of equipment that would allow you to create a firearm on your own. So they come into your house, they take your guns, they take your 3D printer, they take your CNC machine, they take your drill press or whatever you may have, and if it goes that far, that I just wonder, the practicality of it seems so low, but at least it would. On the pro side of it, I guess it would then impose a further criminal liability if the person did produce a gun, but it's not preventative in the way that the idea of the red flag law is designed to be. So I guess it's moot at that point, right? Like being punitive for murdering someone with a gun you shouldn't have, adding a little bit of time to the offense because you had the gun or the material is. At that point, the person's already dead, and really, what do we care about the extra? That's a tough question. So I've got one final question here from the Fog. Says, "Hey Nikki, I need you to shill my PI network invite code, UKIC, the first cryptocurrency to be mineable from a phone app. Just download the app, and one tap away, and you're mining crypto. Have a great night." So, okay, never mind. I thought that was a question, but it was actually just a shilling thing. So, sorry about that. All right. Well, what I'd like to do at this point in time is I'm going to transition into reading all of the other chats that were less than the $20 amount, and kind of going through and answering those questions. You are welcome to stay on the stream as long as you want, but I know it is very late there. It's like 2 a.m. where you are. So if you wanted to exit, I was going to give you sort of final thoughts. It's up to you though, either way.
Actually, if you'll give me 1 second, I'll come right back and I'll answer some questions and then sign off. How was that?
Yeah, absolutely. Absolutely.
Okay, I'll be back.
Okay. Thank you. All right, guys, I'm going to see if there are any questions or comments that have nothing to do with Miss Kendra. Here says, well, we'll leave that one. Let's start here. Bad Vibe says, "You mentioned nepotism. Well, a certain VA has a sister in anime, but not with Funimation, Rooster Teeth, and Okratron. Maybe they don't want to get couched." Ooh, very interesting. Finn Frog says, "Dang it, I'm so late. I haven't had dinner yet, and Nick's stream is starting in a minute." This is just before the show. The guy from that thing says, "Probable cause does not exist. Prove me wrong." Well, probable cause doesn't need to exist because it is what they say it is. Mets 2128 says, "I find the SJW ideals give way too easily to dogma, which becomes fanaticism. Do you agree or disagree with this, Nick?" I don't know if it starts with SJW ideals and moves to dogma and fanaticism, or if it starts with the fanaticism that has bred SJW ideals. It's a chicken and the egg question. I think if I'm being fair, I don't think it has anything to do with social justice. I just think our ideals give way to dogma and fanaticism in general. So that's where we're at a reactionary and divisive point in society that I think that we're just at risk of that in general. So, okay, welcome back. I do have some questions and comments for you, Kendra. This is from Flawless Cowboy. He says, "Come and take it." So, of course, a reference to the Texas canon. The Pie Baker says, "F these overly sensitive, convict them before the crime laws. The first day of the school year following Virginia Tech, some vindictive high school cuck spread a rumor that I had intentions. I was escorted out of the first day orientation assembly in front of the entire student body, had my person searched and suspended, all on one person's hearsay without any form of self-defense." So that's a highly personal and unfortunate story. Guns Beer Freedom says, "Kendra and Nick, do either of you think the court will get their act together with regards to scrutiny, or will they just keep kicking the can down the road for another 50 years? We kind of talked about this, but oh no, I don't have your audio. I can't hear you. Did you happen to mute your microphone by accident?
Yeah, there we go.
There we go. Okay.
Yep. Sorry about that. Yeah, no. God, and I just gave you my answer too.
Sorry.
What was the topic? Sorry.
This was, do we think the court will get their act together with regards to scrutiny?
No, they're going to keep kicking the can down the road, and they'll do it by basically, they'll probably at some point give more guidance on what form of scrutiny, but it's going to be the kind of guidance that provides no guidance whatsoever. So it'll be some form of heightened scrutiny, like intermediate scrutiny, but they'll throw in a couple of extra words or some extra language that makes it sound like it's some sort of objective standard, but that's really going to be applied however any court wants to apply it, like they're doing now. It's kind of what I figure.
I hate agreeing with you on that.
Yeah.
Night of Hopex says, "Hi, normal lady. Welcome to the weird part of the internet. I apologize for all of these degenerates." So there are some chats that are a little bit interesting. Like I said, I'm overtly free speech, and so some of the things that people send in are a little bit weird. Landre Scarlett says, "Fun red flag adjacent situation. Washington state requires you to give up medical confidentiality when purchasing certain guns, HG assault weapons, for background check / yearly rechecks. Totally unrelated. Medical records can indicate if you use marijuana, legal in Washington, but ... So, yeah, have you seen anything? I don't think Florida has that strict of checks for purchasing firearms where they require disclosure of medical records,
No.
or anything like that. Okay.
No.
So good job, Washington State. That's a joke. Guy72 says, "Considering 50% of cops commit domestic violence, can they have their firearms confiscated by an RPO? Or is the feudal caste immune from laws meant for peasants?" And another question, "What's to stop the criminal from using this law to disarm their victims?" So that first question, with a high percentage of, I don't know if it's 50%, but I've seen the idea that police have a higher percentage of domestic violence. Can their firearms be confiscated by an RPO?
Oh, they can. And in fact, the first district court of appeal case that I mentioned where the law was upheld, the guy was a sheriff's deputy. It was really an unfortunate case because the law had just gone into effect. Nobody knew how to use it. This was a rural county. And this guy found out that his longtime girlfriend had been cheating on him with somebody else in the department. So he was naturally very angry. And he said something that he shouldn't have said, something like, "Yeah, I just want to blow the guy's face off," or something like that. Which you might expect somebody to say if he were pissed off about finding out that his lover was cheating on him with one of his colleagues. So stupid thing to say, but definitely not a true or credible threat. They had him Baker acted. So they took in their own deputy to be Baker acted. He was quickly released, but they pursued the RPO anyway, which effectively ended his career in law enforcement.
Wow, because there's often an exception in many firearms laws for active law enforcement members to at least have a firearm while on duty, or in the commission of their work, which I think some states interpret to be all the time anyway. Yeah. So that's I'm impressed that at least they were consistent on that. That's interesting. Maybe every cop should be RPO'd.
I'm totally down with it. I will be a consultant on those cases. For them. Yeah.
So another question: what's to stop a criminal from using this law to disarm their victims? Have you seen anything like that where you kind of brought up a domestic situation before where it's disproportionately men being disarmed in this, but is there any situation where that you've heard of at least where let's just go stereotypical and say a man uses the RPO to disarm his former spouse who he has a history of battering, and then goes ahead and assaults them when they're after the RPO has taken place? Have you heard of anything like that?
No, there was okay, yes and no. So there was a case, I want to say, out of northern Florida. I could be wrong about this, but basically there was a guy who got an RPO against him because of a dispute with his neighbor, and then the neighbor ended up killing him. So the guy who had the RPO against him was disarmed, and then the neighbor who he was having a dispute with was ultimately the one to kill him. And it was some, Kentucky Fried bullshit. I don't know. But
that's so did the neighbor call in to do the RPO too?
Yeah, the neighbor called in the police and that set the wheels in motion for the RPO to disarm the guy who was ultimately killed. And it was incestuous. It was very yeehaw. But that something similar did happen.
It's amazing though that that's the meme, right? Like that's the fear, is that someone will call the police, have them take my guns, and then they'll come kill me and I won't be able to defend myself. That's the scenario that if you tell the person on the street corner at the bus stop or whatever, you're like, yeah, this is the danger of these laws. They'll say, that's ridiculous. Of course that won't happen. And it actually did. I even thought that there was no way that had occurred.
Yeah. Oh, but along with kind of what you were saying, I did have a case where, it was my client was an older. He was like maybe 50, sure. And his girlfriend was significantly younger. I think she was 21. And she being 21, she was batshit crazy. And so she started, but
hey, we all were 21 at some point.
I was there myself, so I remember. This is hideous. But they broke up, and she started stalking him and his daughter. And at one point, she waited outside where he worked all night, and so ambushed him when he got to his vehicle. And he said, "Look, I can't remember what her name. So let's call her Amber. Amber, you can't do this. If you don't get away from me, I'm going to call the police." And she just kept on ranting and raving. So he called the police. They pull up, and before he can go over and talk to them, she runs over and says, "He's been threatening me and this, that, and the other." Yeah, and they take him to a Baker Act facility. They slap him with the risk protection order. Well, I got them to dismiss the RPO before it went to a hearing because I found out she ended up going onto Craigslist and putting gay sex ads in his name under his phone number. And I covered all of this. And I was like, you got a problem with the credibility of your witness here, buddy. And so the sheriff dropped it. But yeah, it's wild. It's wild.
Oh my goodness. That's a fantastic story. Oh, that leads me back to a question I had for you. So sheriff shows up at your door. What do you do? What do you say? I noticed on your website, you said you don't have to sign the paperwork. You have rights. contact you. So what does that look like? Because that's sometimes hard for a person when police are at their door to say, nah, fam, I need to make a phone call. So how does that work for it?
Yeah, well, so I want to make it clear that you're not doing yourself any favors by not handing over your firearms if they haven't already been turned in. It is a 5-year felony, and they've got very broad powers to go and ask the court for a search warrant. And they'll come in SWAT style to your home. And if there is another firearm there and you haven't given it up pursuant to the temporary ex parte order, you will get hit with a felony, and they are prosecuting these. But you don't have to sign any paperwork. You never have to sign any paperwork. You don't have to acknowledge receipt of the documentation. In fact, I always recommend don't sign anything until you've been able to actually contact a lawyer. In this case, you know, really all you're signing for is receipt of the petition and the order. But make no mistake that you're not going to help yourself by telling them to go fuck themselves. I'm not giving you my firearms, because they will find a way to make it even worse for you. The best thing you can do is just fight it head on, you know, and that involves getting a lawyer if you can.
So what you would suggest to someone, sheriff shows up at their door and says, we've got this order that says we get to take your guns. You turn over the firearms, but you don't sign any of the paperwork that they give you, and you get a lawyer right away. Is that
right?
That's the ideal sort of scenario. And that's something that I've talked about with people too. Respecting your rights, preserving your rights against unlawful searches, for example, in the criminal capacity, you know, yelling, am I being detained over and over, and trying to prevent the police officer from executing the search isn't actually going to help you get home that day. But preserving your right to refuse consent for the search may help you in the long run.
Right.
If a cop wants to search you, they're going to search you, and complying with it, but maintaining that they don't have the right to do so is important. And getting a lawyer right away, of course, would be important to that. Thank you for I meant to get to that earlier, but I did not. And yeah, I know there's been a shooting or two based on these types of actions, right? Where the police showed up, said, hey, we need to take your guns. And the person said, no way, you can't. I have a Second Amendment right. And then a shootout occurs, and it usually ends up with the person dying, not the police. Not the police dying, which either, of course, is unfortunate, but I know that that's a thing. Nero says, show Bob and vegan. Don't even worry about that. If you don't know what that means, and if you do know what that means, I'm happier for it.
Bitch lasagna.
Nero says, that crooked shit doesn't happen in Mississippi, you crooked Yankees. And then Nero says, north of I-10, south of God. Midwest Stone says, can you get Andrew Yang on? He's an ex-lawyer himself. I don't know if Andrew Yang would come on my show, but I'll send an invite to his campaign.
Tell him to bring money. Yeah. I'm down.
Yang, I need my grand, and show up on my YouTube, please. Mad Black Man Lover Entertainment says, any of y'all looking for thug love? See, this is what I was talking about earlier. And then he says, anyone looking to bend a thug over? I'm not personally, so... CC1138 says, a good commie liquor would be my favorite. Ararat 10-year Akhmadar brandy, loved by Stalin himself. And then, oh my goodness, I apologize. Mad Black says, I'm a 42-year thug who enjoys men inside me, word up. Mad Black Hose Mad says, you ain't thug till you've been bent over in prison. There's a theme going on. I don't know if you are familiar. Pendergast 21 says, innocents end up on the sex registry. Hang the ones who need it. No need for the list. Wow. What do you think, kind of expanding on that comment, what do you think about capital punishment for sex offenders as a concept? I know that's kind of a way out there question, but...
I don't really see it as being a useful tool. I think that when you're basically incentivizing the person to go ahead and kill the victim, because what's the difference anyway? Whether I kill them or only sexually abuse them, I'm going to get capital punishment either way. I think that's problematic. I don't know that there's any deterrent effect that was proven back when we did have capital punishment for those sorts of cases. So if there's no deterrent effect, if it's really only for retributivism, yeah, I'm not big on retributivism for its own sake.
Sure.
Yeah.
Now, I had a convicted sex offender on the show. He was convicted much younger, when he was, I believe, 15, 16 years old. He was convicted of several counts of possession of child pornography. Or no, I think he pled out to one count. He was charged with tons and tons of counts of it. And his what was interesting is his perception of the problem was contrary to the statistics and what we talked about earlier. He said there is no cure for it, and that he himself would always be a danger, and the only barrier to that danger was like an accountability network of people around him who would keep him from being in a situation where he might offend. So that was kind of a unexpected answer from that person, but I don't know.
Yeah,
I'm just adding thoughts. The Red Pill Nation says, I have a 5250. I'm nonviolent, which a 5250 is, that's basically a Baker Act, if I understand right. I'm nonviolent. I have no convictions. I lost gun rights for life due to drug use, held in mental hospital. Can I get my rights back? I'm nonviolent and have never harmed anyone.
Yeah, you can petition the circuit court. I'm assuming this person is in Florida, but basically you can petition the court for them to lift your disability, your firearms disability, and that is something that can be done. I'm pretty sure it can be done in most, if not every state.
Hypothetically, if the person is in Florida, is that a service you engage in? Could they contact your law office?
Absolutely, yeah.
Perfect. Tucker says, should counsel be appointed in immigration cases?
It depends, because there are a lot of different types of immigration.
Sure.
That's such a broad. There's criminal immigration cases. There's others. So I don't know.
Interestingly, I think a deportation action, which would be, I believe, criminal, they have to appoint. Well, no, I don't think they do appoint counsel.
Yeah, I'm not sure about it. I just know that like Johnston v. State, and then a follow-up case, basically deportation, like getting on the vague argument regarding the RPO law, just looking at the notion of what makes a law unconstitutionally vague in the first place. You had a string of cases authored, actually, the first one at least was by Scalia, throwing out some language of the Career Felon Act, basically saying that it was too vague to support convictions. And then there was a follow-up case that concerned deportation, and the court said, this is almost the exact same language, and we have always held that deportation actions are quasi-criminal. So maybe not criminal through and through, but criminal, the severity of being left stateless without any place to go is such that I think that it's a type of proceeding in which due process rights are heightened. So.
Okay. Yeah, it's interesting. I mean, I don't practice in immigration law, but I have sat in the immigration court in Minnesota, and all of the defense counsel was privately hired. There was not an appointed counsel. So I'm kind of curious about that now. Yeah. The Red Pill Nation says, I cleaned up my act. I'm drug free, no convictions. I just got held in a mental ward. Can I get my rights back? I'm not violent. I did drugs in the past. We did answer that question. At least in Florida, you can petition the circuit court for it. If you're not in Florida, reach out to a lawyer in your state who practices in firearm law. They'll be able to kind of guide you on that. But it likely will, there's going to be a cost involved, unfortunately. John Albert says, hey, Nick, been a while. Just wondering if it's okay to ask Kendra, what she thinks of the Vic case and Judge Chupp if she knows about it. I'm going to assume you have no idea what he's talking about.
No, I don't.
Okay. It's a ongoing defamation case in the anime industry, which is part of why I asked you if you were an anime fan earlier. But yeah, it's a case I've just been covering on this channel for the past 8 months. It's in a weird place right now. So, Cemetery Lady says, can an EMT company be held responsible for one of their employees being shot after they asked for vests in high crime areas? I've been shot at before too. Gosh,
possibly.
Maybe under an employment law, where they would have some sort of duty to provide a safer work environment, but I don't think there's an explicit legal theory on it.
Yeah, that's new to me.
The main thing you've got going for you is the nature of the employment relationship. I would think that would impose some sort of duty, especially if they've been asked for specifically due to the notice being provided of the high crime. But it'd still be a tough shot because, no pun intended, because the person doing the act would be unrelated to the company. So, but yeah, I mean, I consult an employment lawyer in your state, because if they are responsible for that, and you may not even need to be shot to have standing for it. If they're responsible, if someone else is shot, there's likely penalties that an employment lawyer would salivate over. Joe Nathan Joestar says, what's your opinion on counties that don't have Second Amendment? I'm not sure what he means by that, but maybe sheriffs that refuse to issue carry permits. Hawaii had that issue where it was so difficult to get a carry permit in Hawaii that the appeals court eventually had to rule that there's no meaningful way to achieve one. Do you have any opinion on that, or are you familiar with that issue at all?
Not really. Yeah, I'm going to leave that one alone.
Okay. Rogue says, have you done any cases involving TV remotes?
TV remotes?
Like a universal remote. I would assume in some sort of battery scenario where someone was maybe hit with a TV remote or anything like that.
Yeah, I have no idea.
Okay, so you haven't done any of those cases personally.
No, and I'm still trying to figure out exactly what we're talking about when it comes to like the connection between remotes and firearms.
I don't think there's any connection between remotes and firearms. I think it would be like if someone were to batter someone with a TV remote specifically.
Oh, yeah, haven't seen that. No.
Joe Nathan Joestar. Oh, he clarifies countries that don't have a Second Amendment. What's your opinion on countries? That's a big difference.
I think it's sad. I mean, if you look at the UK right now, and you've got the mayor basically saying, yeah, we need to get rid of the points on knives. What do knives need to be pointy for? It really
listen, they can be edged, but no pointiness. We want them to
sad.
Blunt people with them.
Yeah. No, I mean, and it's just, you want to laugh and cry at the same time when you see a country like the UK, where you can see the slippery slope in action. I'm usually not a big fan of slippery slope arguments. But in this particular case, it's, how do I feel? I feel bad for them. I feel bad for their citizens.
You have to really ask from a legislative matter, where do you draw the line? Like if it's pointiness today, it's the edge tomorrow, because it's going to go from stabbings to slashings. Like that's just a thing that's going to happen. So then do you have like you can't use some sort of knife that is incapable of cutting skin? I mean, I don't know how we develop, like if we develop this miracle technology, what do? We've got scissors that are useless. I have a whole bunch of kids, so I'm all familiar with safety scissors that don't even cut paper, but like I can't cut the chicken if I can't cut my own hand. that's just a real issue. Finn Frog says Amber Alert. I think that's in relation to your Amber story. She sounds like a true gem. Samantha Schoner says, I've been stuck inside all day waiting for Typhoon Hagibis to hit Japan. Thanks for keeping me distracted in the meantime. Hey, good luck, buddy. Stay safe. Well, Samantha, I guess, I don't know if buddy's the right term, but I call everybody buddy. So, okay. Bad Dragonite asks, what is your favorite, or what is your best Florida man story? You are in a notorious state.
Oh my God. Yeah.
Like anybody who like cut the face off of a crocodile and wore it as a wedding party or anything like that, or?
Well, I think, the story that always pops out in my mind is the one where the guy literally, I think he ate some spice or crocodile or whatever he had, some synthetic cannabinoid, and literally chewed a guy's face off down in Miami while they was on the bridge.
That was the bath salt thing, I think.
Yeah, I don't think they ever pinned down exactly what he had taken, but just literally chewed some motherfucker's face off. It's like, oh, that's like hardcore Florida right there. But
yeah, that's all of it.
Yeah,
they should just rename Florida to Flacca Zone. And okay, this is from Fluffy Side Up. Says, in my opinion, these red flag laws don't really do anything to protect a suicidal person. If someone really wants to harm themselves, they'll find a way. And the only time I think you should have Second Amendment taken away permanently is if you murder in cold blood, not defense. Any opinion on that?
Yeah, well, I think, that second point gets back around to what I think a lot of my colleagues had pointed out, which was that, if somebody is too dangerous to have their enumerated Second Amendment rights, then they're probably too dangerous to be free. So, use the criminal laws that are on the books. If somebody does make an actual threat, then charge them with it. If somebody is actually mentally ill to the point that they're dangerous, take them through mental illness court. But, I'm kind of beating a dead horse myself. I'm just saying the same thing over and over again. But.
Look, as long as you're not chewing that motherfucking horse's face off, we're fine. If you hear me chuckling, it's because I'm just replaying that in my head. It was perfectly stated. Okay. Bad Dragonite says that crooked shit happens all the time in Mississippi. Knight of Hopex says, gotta say this, anyone with the slightest grip on reality should be expected to control themselves. There is nothing short of insanity or maybe drugs that overwhelms your ability to choose. Sane adults don't need a network of friends to babysit them. BS. So I think that was in response to the sex offender that I had on the stream earlier. And then finally, this is the final one, and then we'll go ahead and wrap up the show. Bad Dragonite says, great guest tonight. Off topic, just going to take a second to remind everyone interested in the hashtag boycott NBA and hashtag boycott Blizzard to tune in tomorrow at 10 p.m. Central to the show with Mark Kern, former lead developer on World of Warcraft, scheduled as a guest. So yes, if you're interested in the China shenanigans going on with private companies in the United States, check out the show tomorrow. Well, Kendra, it's been wonderful having you on. I want to give you a moment to say whatever you want to the audience. If you want to tell them where they can find you, or if you want to, if you have any books or articles that you suggest people read, tell them where they can find them, or any last thoughts. Please go ahead and share them.
Sure. Very briefly, if you encounter a risk protection order or red flag law petition, then do what you can to scrape together some money for at least a consultation with the lawyer. Don't try to go it alone. If at all possible, go ahead and get yourself some representation. Number two is, like, I really can't emphasize enough the importance of going and speaking with your legislators about what concerns you, because bitching and moaning on Facebook or online really isn't going to sway or move the needle at all. And then I guess I would leave your audience with the immortal words, don't ever talk to cops.
Oh,
If
thank
cops
you.
are ever talk to you, don't talk to cops. You don't have to, and don't ever consent to a search, and you'll be good in life. I think that
Yeah,
works to
some
live by.
people may not realize out there that even if you think the cops have you dead to rights, they might have lost the file. Anything could happen that would prevent them from actually prosecuting the case, and you talking to them may actually give them the ability to prosecute when they otherwise have lost the evidence. And they can lie about it, they can pretend that they know everything, they can pretend they can prove anything, but none of that matters until you talk to them and confirm it. So I'm gonna second that. But well, Kendra, it's been an absolute pleasure. I'm gonna close out the stream and then I'll say goodbye to you in private in just a moment. Thank you guys for joining us tonight. Thanks for hanging out and asking great questions. Oh, Tucker asks for LSAT tips. Do you have any tips for the LSAT?
Yeah, don't take it. Don't become a lawyer.
I like
you.
that. That's good advice.
Yeah.
Actually, it is really a poor career move right now. There's so many lawyers graduating each year and so few retiring or dying that maybe we need some sort of purge. But really, it's a tough field, and I think most lawyers out there would agree with that. And then finally, Orocha Taco says, sad part is if we're not careful with China, it will spark World War IV, but no one owes debt to anyone if the people you owe debt to is gone. All right, guys. Thank you for joining us tonight. I'm going to close out the show, and it's been great. You guys have a good night. Peace. Peace.